Good morning, everyone, and welcome. Happy Monday morning and happy Global Entrepreneurs Week to you. Today, we have a special treat for you, and it is just the beginning of a week long lineup of celebrations of what is Global Entrepreneurs Week across the world. With more than 4,000 registrants in our virtual event since April of this year, the JBDC Virtual Biz Zone is our weekly feature as you've come to know it. But this week, we have made it into a huge trifactor. We are going with the week-long celebrations of global entrepreneurship in partnership with the Jamaica Intellectual Property Office. And we will be bringing you this morning, Monday, November 16, and tomorrow morning, November 17 on Tuesday, features on the Patent and Design Act 2020. Now, these are going to be looking on the updates that have been made to these patents. And this is very much in keeping with the theme of this year's Global Entrepreneurship, which is ideate, innovate, activate. And we are actually looking at how it is that we can boost and promote innovation towards the persons who are in the creative industry and those who are looking to introduce new industries, new sectors to our entrepreneurial sector. Now, across the week long, today we have our virtual biz zone in the morning at 10, and we also have our features at 1 o'clock. And at 1 o'clock this afternoon, we're going to be having a feature of the Business Dialogue Forum, which is our staple in the Global Entrepreneurship Week. And the theme for this afternoon session is social entrepreneurship, unlocking youth innovation. And this is going to be in the form of a panel discussion headed by our very own Harold Davis, the Deputy CEO, and some other interesting persons who will be sharing in this matter. Now, let me also give you an idea of what's going to come for the rest of the week. So Tuesday, we have more of the virtual biz zone at 1. And on Wednesday, we have partnerships in growth where an important signing with the CL Dunn and Bradstreet and the University College of the Commonwealth, Caribbean UCC, will be signing what is an agreement to assist the local SME sector with having access to information that will have them make crucial decisions about whether or not the businesses that they're looking to partner with and do business with in Jamaica or across the world are actually legitimate and worthy of doing business with, because they have a database that gives information that gives almost like a certificate that this company is a legitimate company and worthy of doing business with. Then we also have in the afternoon JBDC in concert. We have on Thursday the virtual craft biz zone and brand Jamaica design lab. And on Friday we have the entrepreneur's journey, our usual feature, but this time it is going to have not just one entrepreneur, but we're going to be looking at the 4 nominees for this year's JBDC Boss of the Year Awards. And at 1, we will, after having that discussion, announce who the winner, the boss man and the boss woman of 2020 will be. Now, that's the lineup. I hope you have been sufficiently intrigued as to what it is that we will be doing this week. And now you are prepared for what we have lined up for you this morning. Our first session, as I mentioned before, will be on the new Design Act. And this will be presented, as I said, in partnership with JIPO. And from JIPO, we have Ms. Adrienne Thompson. And she is the manager of trademarks, designs, and geographical indications. Ms. Thompson has been an attorney for the past 14 years, specifically in the fields of intellectual property law and medicinal chemistry research. She is qualified to practice law here in Jamaica and has been so since 2013. She's also qualified to practice in the United States, in Missouri, since 2008. She holds a Juris Doctorate from the Tulane University Law School, Louisiana, and a Bachelor of Arts in Biochemistry from Vassar College, New York. Quite an impressive resume. Adrienne, are you here with me?
Hi, good morning.
Wonderful. Welcome, Adrian. And looking forward to hearing about the new design act and the updates that are relevant to our entrepreneurs.
Okay, whenever you're ready.
Ready when you are.
Okay, so let me just share the screen. Okay, so good morning, everyone. So again, my name is Adrienne Thompson, and I'm here at JIPO. And so what we're gonna do is today is talk about the design framework in Jamaica. And so we're gonna talk about where we're coming from and where we're headed and some of the key differences with the new act. Okay, so before we get into that, just a little bit about JIPO. So JIPO is the Jamaica Intellectual Property Office. It's a statutory body that was established in 2001. It's under the Ministry of Industry, Investment and Commerce. And it's the statutory body that's responsible for the administration of IP laws in Jamaica. So at JIPO, what we do as part of our mandate is a lot of public education on just how people can protect their intellectual property. We also work on developing the IP laws and policies to make sure that we're consistent with what is best practice in the rest of the world. And we also primarily are responsible for registration of IP rights. And so currently we are the registry for trademarks, designs. We also register patents, geographical indications, and we also have a voluntary copyright register. So what are intellectual property rights? So in a nutshell, intellectual property rights are legal rights that result from a creation of the mind that is fixed in some kind of tangible form. And so it can be in any field of intellectual activity and ranging from scientific to artistic works. Depending on the area, one or more intellectual property rights might be used to protect it. So we'll go into that as well. So what we have here is just an overview of the IP right framework. And so under the big heading of intellectual property, you have industrial property rights, which is where patents, designs, trademarks, and geographical indications fall. And then you have copyright and related rights. So copyrights and related rights are usually used to protect musical works, artistic works, broadcasts, musical performances. And then we also have a third category for called traditional knowledge, and you'll also see the term traditional cultural expressions. And so what traditional knowledge, or TK or TCE, as the abbreviation, what those refer to are collective rights that are usually in the context of a local indigenous community. And so it's knowledge that tends to be passed down from generation to generation. So a common example would be for your Anansi stories, or some old time remedy that everybody in a particular community knows. So that kind of intellectual property tends to belong to the collective, and so it falls under the traditional knowledge, traditional cultural expression regime. So today we're focusing on industrial designs. Tomorrow, Jason Wongsam is going to go into more detail into patents, but briefly, patents refer to intellectual property rights that are used to protect inventions. And so a patent is usually solving some kind of problem. So it's a technical solution to a problem. And a patent pretty much gives you a monopoly on the invention. And so the inventor can control who can use their invention for a specific period. Um, And then we're going to touch on trademarks briefly later on in the presentation. Okay, so industrial designs. Basically, industrial designs are what makes an article appealing to the eye. It's the ornamental or aesthetic aspect of an article. It's the thing that draws your eye to it. And that is what industrial design is in a nutshell. It can be used in pretty much any industrial field across industries. Basically, the definition of a design is something that it can be the shape of the thing itself, so it can be three-dimensional, or it can be a pattern that is attached to the design, so it can be two-dimensional. And so the design may consist of three-dimensional features, such as the shape or surface of an article, or of 2D features, such as patterns, lines, and color. So this is pretty much the old or the current definition of design, but there isn't a huge difference in the new definition under the design law. So as I said before, industrial designs are useful because they are what make an article attractive and appealing, and it can be applicable in several areas of manufacture, including textiles, medical devices, vehicles, buildings, pretty much you name it, you can probably protect it with industrial design. Locally, we have a lot of designs for articles of clothing, shoes, jewelry, primarily the areas where we see design applications. So here we just have some examples of designs. So the thing that looks like a jellyfish, those are lamps. You can use a design to protect furniture. And so you have that orange chair. It's an interesting shape. Like I said before, shoes are very popular in Jamaica. So Bridget's have several of their designs registered here. And then, you know, in the middle of the slide, you see the Toblerone candy bar. And so the actual shape of the candy bar is unique because of all the triangles. And so that shape is also a registered design. So here we just have some more examples, some more shoes, perfume bottles, the Coca-Cola bottle, that shape that most people are familiar with is another well-known design. And so again, the design adds to the commercial value of the product because it's going to draw the consumer's eye to the product, and so it can increase the marketability of the product. Okay, so how do you register design? Currently, you fill out a form and you are going to tell us your name, give us your particulars. You're going to tell us the nature of the design. So what is the thing that you're trying to protect? What are you applying the design to, for example? You'll tell us the class or classes of goods that the design is to be applied to. And then you'll have to tell us how this design is novel. How is it new? Because that is one of the conditions for acceptance of a design. And then you're also going to have to give us different views or representations of the design from different angles so that we can, one, look at these pictures and determine what the design is, and also so we can compare what is already registered with what you're submitting as a new design. So the current cost for registration of design is $1,500 per design in one class. And so, as I said before, one of the conditions for acceptance of the design is that the design has to be novel. And so it cannot be known or used in Jamaica before. It also has to be original. So you can't just pretty much copy somebody's design and make a minor change. It has to be original. And finally, under the current design regime, the design cannot be scandalous or contrary to law or morality. So those are some of the things that we'll look for. So the procedure is that once you submit the form, we will basically intake the application and the fee, and we'll enter it into our intellectual property administration system. And then we will basically create a file for your design application. Once that happens, the office will send you an acknowledgement letter saying that, yes, we have your design. And then we will perform a search. And so we're going to then search the design registry to see whether or not the design has already been registered. And so once we perform the search of the registry, we generate a search report. And then the search report is submitted ultimately to the registration officer that will examine the application. And so what the registration officer or the examiner is going to look for is whether or not, based on the search reports, the design application is original and it's new, and whether or not it's offensive or scandalous. And so we currently are going to look at novelty in a local context. And so we're looking primarily at registration or use in Jamaica. And so if the design is novel, original, and it's not scandalous, we will then send you a certificate of registration saying that your design has been registered. So what registration gives you is that you're protected for 15 years. After the 15 years, you can't renew the registration. The design essentially is open to the public domain. So you're essentially getting a monopoly on the use of the design for 15 years as the design owner. And during these 15 years, if somebody is using or imitating your registered design without your consent, then you can sue them for infringement. So design rights, like other industrial property rights, are territorial. And so what that means is the registration of your design in Jamaica means that the scope of protection for your IP rights is within this jurisdiction. And so if you want to register your design in another jurisdiction because you're planning, for example, to export your products to another market, then it would be prudent to register your designs in the markets that you're going to be using the products so that you have grounds for an infringement action in those jurisdictions as well. Okay, so that is what obtains currently. So again, the reason why we're here is to talk about the new bill, which is the new Patent and Design Act. So the current act is pretty dated. It's the 1937 Design Act of Jamaica. And so that act is set to be repealed and replaced with the Patent and Designs Act, which was introduced in the Senate earlier this year and should come into effect by the start of the new financial year. And so again, the new act is going to repeal and replace the current design law. And one of the main features of the new act, apart from just updating the design regime and bringing it in line with what obtains worldwide, it also includes utilizing a different classification system for the goods or services that you're going to protect the designs under. And so we're going to be utilizing the Locarno classification system as opposed to the current schedule or classification. So we'll talk about that further on in the presentation. Another big feature of the new bill is that it will allow us to join the Hague system. So the Hague system is a treaty that is administered by the World Intellectual Property Organization. And what the Hague system allows for is it's an international registration. So it's basically a shortcut to register your design in foreign jurisdictions, because under the Hague system, you will make an application to the World Intellectual Property Organization. And then based on that international application, you can select what countries you seek to protect your design in. And so it's kind of like a common application where by filing one application and paying the relevant fees, you are gaining entry into different jurisdictions to protect your design. Okay, so one of the changes under the new law is the definition of design has changed. So at the top of the slide is the definition of a design under the old act, which is very long, but basically it talks about 2D or 3D features on natural articles or any article of manufacture, and then it goes into how the design is applied. So it says whether design is applicable for pattern or for the shape or configuration. So it's pretty long, and then it talks about different ways that you can apply designs. So printing, painting, embroidering, weaving, sewing, etc. And so the new law basically takes out a lot of the mechanisms for applying the design, and it simplifies the definition. So under the new law, the definition of a design is any composition of lines or colors or any three-dimensional form, whether or not associated with line or colors, which gives a special appearance to the product of industry or handicraft and serves as a pattern for a product of industry or handicraft. So it basically simplifies the definition. Apart from the definition, another change under the new bill is that the criteria for registration has changed. And so, whereas before, the design only had to be new, original, and not scandalous, now the terminology has changed under the law. And so the design has to be new, it has to have individual character, and it cannot be contrary to public order or morality. So what do those things mean? So novelty or newness is pretty much the same thing. So it says before the filing dates or priority dates, the design has not been made available to the public anywhere or anytime. So what is important under the new law is that the design has to be novel, and we're not just looking at local novelty, because it widens the definition. So it can't just be new to Jamaica, it has to be new pretty much worldwide. One of the exceptions is that you have a grace period of 12 months where if you file your application, but 12 months before the filing date, there was some kind of unlawful disclosure of your design or some kind of breach of confidence, or if you displayed your design at a local, regional, or international exhibition, basically, as long as you put that disclosure in your application and you have a 12-month grace period from when the disclosure was made and when you can file the application. If you disclose it beyond 12 months, then it would be in the public domain and it wouldn't then qualify for registration because it wouldn't be novel. So you just have to pay attention. If you're so for example, if you're going to some kind of conference or trade show, make sure that you record the dates of the trade show so that you know that from that date you have 12 months to get your application in so you're not barred from protecting the design. Okay, so apart from novelty, it also has to have individual character. So again, this is probably similar to the old standard where it has to be original. Basically, the impression of the design has to be that the design is something that doesn't exist already in the public domain. And so if the informed user, so the person who's going to be using the design or somebody familiar with the type of design can look at your design and say that is different from what already exists in the space, then it will pass the individual character bar. And then, like I said before, the design can be contrary to public order or morality. So this would fall under the old law. They use the term scandalous. So it's a similar concept where you're trying to prevent designs that would, for example, promote crime or violence, or that would be offensive to a portion of the population, or, for example, designs that are sexually explicit. Those would be barred from registration under this clause of the Act. Okay, so another feature of the new law is that it has quite a long listing of designs that won't qualify for registration unless you can satisfy a particular condition. So, for example, the first bullet where it speaks to coat of arms or the national flag. So this is currently the practice at JIPO, where both trademarks and designs that contain a national emblem or symbol, we won't allow you to register it unless you can show that you have the permission to use the national emblem or symbol from the government of Jamaica. And so currently that authority to grant or deny consent is at the Office of the Prime Minister. And so we would send you to the Office of the Prime Minister when you submit your design application, as long as it contains a flag or another national emblem or symbol, and then you would have to get their permission to use the national emblem. Similarly, if your design contains the name Jamaica or the map or colors of Jamaica, anything that is, suggestive of the country name Jamaica, then that is also not going to be allowed to be registered if the registrar thinks that it's misleading to the public. And so if your design, has all of these references to Jamaica, but in actuality, there is no connection to Jamaica at all, and it's intended to mislead the public, then that design wouldn't qualify for registration. So you'd have to then show the registrar that your design isn't misleading. So in the same way that we protect the country name of Jamaica and the national emblems or symbols of Jamaica, we also will protect the name and national emblems and symbols of other countries. And so again, the standard is that the design can't be misleading. So you can't just be using another country's national emblem or symbol just because you think their flag, for example, is pretty. Like you have to consciously try to not mislead the public as to the existence of a connection between the origin or nature of the articles that are going to be using the design and the country that you're claiming that designs come from. Another example of non-registrable design is if you're using the name or emblems of international organizations. So a common example would be the Olympics Association, for example. So you can't just use the 5 rings on your design because you think, it will make it prettier or more marketable. Like those emblems are protected internationally. And so again, you'd be barred from using that in the design unless you have the consent of the international organization. Under the current law, you also cannot use a registered trademark or an unregistered trademark that belongs to somebody else in your design unless you have the permission of the trademark owner. Similarly, if it's a copyrighted work, you have to get permission to use the copyrighted work in your design. And so you can't, for example, use, I don't know, the image of Harry Potter in your design because you know that it's a popular children's book, because chances are you'll be infringing on the copyrights and trademark rights of J.K. Rowling, and so you need her consent. Similarly, the image or likeness of an individual can be used in a design unless you have consent and permission from the individual. Also, in the context of famous people who have passed, you need to get the consent of their estate to use their image. And then finally, you cannot use a design that contains the traditional knowledge or traditional cultural expression of indigenous or local communities unless you have authorization from the relevant community, or where it's not practicable to obtain such authorization, you have to satisfy the registrar that such use isn't likely to mislead the public. So again, this whole concept of misleading the public is, throughout the new law. And so you have to pay attention to what you're using in your design and get the relevant permissions, or the registrar will refuse your design application. Okay, so I mentioned this before. Another change is that you're going to be examined for worldwide novelty as opposed to local novelty. Yeah, the second bullet we've talked about
Janelle?
already, where...
Hi, Janelle. Sorry to interrupt you, but I've been following the chat and I thought a question is quite relevant to where you are. So before you move on, someone was asking, does consent require something in writing?
Yes. So you will need some kind of authorization. Usually it's a letter from the owner of the right that says, I, Adrienne Thompson, authorize you to use my trademark or copyrighted work in your design application. And so you just need to give the office some kind of indication that you actually have consent from the owner of the rights. Similarly, the Office of the Prime Minister will give you a letter authorizing use of the flag for a particular design in writing. So yes, it is in writing.
Thanks.
No problem. Okay, so in addition to worldwide novelty, which is new, so we're going to be looking to make sure that the design hasn't been registered anywhere else in the world. A new feature of the law which is consistent with international practice, is that you can't protect a design that is functional. So you can't protect something that is, the design is a direct function of what the thing is meant to do. So what that means is, if you are trying to protect some kind of screw, for example, and the screw is round and it has specific grooves. And the reason why it has those grooves is that it's not ornamental, it's not aesthetic. It's designed that way because that's the only way for it to function. It's the only way for the screw to fit in the particular socket, for example. Then that portion of the article, it would be functional. And so because it's not aesthetic, it's not ornamental, you can't protect that element of the design. And so, like it says, design protection is not applicable to anything in a design which serves solely to obtain a technical or functional result. However, if you have something that, you can have something that is complicated in that it has a functional portion, but then it will also have an ornamental portion. And so what you would do is, in your design application, you would point out to the office what is the ornamental aspect of the thing that you're trying to protect and what you're not trying to protect due to its functionality. So under the new regime, we also will look for functionality, and that could be a bar. And then the last bullet, under the new regime, we have a right to priority. So if you have filed a design application and your design is registered in a convention country to the Paris Convention, you can file an application to register your design in Jamaica, and you can claim priority to that earlier application, as long as the subsequent application is filed within 12 months after the parent application. And once you do that, the filing date for your design, so the design in Jamaica, the filing date will get the priority or the filing date of the earlier design application that you filed overseas. And so that can be pretty powerful, because if you are going to say that somebody is infringing your design, then the use or the ability to point to an earlier filing date can, in many cases, make or break whether you actually have a valid claim for infringement. Okay, so I mentioned this earlier. Under the new law, we're also going to be using a different classification system. So under the 1937 law, there are 12 classes for registration of your design. So it's very broad. For example, you'll have designs that are using primarily wood, that would be one class, or metal, that would be another class. And so it kind of focuses on the materials in the product to categorize the goods, but that way of classification is very dated. And so under the new regime, we're using the Locarno classification system. And so the Locarno classification is an international classification system used to classify goods for the purposes of registration of designs. And so why Locarno is powerful is that it is a lot more detailed. So you have 32 classes, and then you also have subclasses. So it will go down into very specific detail into the elements of the design. And that is powerful because, again, we're going to be using worldwide novelty to determine whether or not your design qualifies for registration. And so by using the Locarno classification, we're essentially standardizing how we categorize designs. And so it will help us to search the designs worldwide. And then it will also help if you're going to be applying in other jurisdictions, you don't have to reclassify what your design is. If you're using Locarno and then you're going to an overseas jurisdiction, then you can use the same standard in a different jurisdiction. So that's one of the benefits of the new law. Okay, so another change is that under the 1937 law that is currently being practiced, once the design is registered, it's registered for 15 years. Under the new regime, the registration is going to be valid for 5 years. And then you have the option to renew the design in 5-year increments twice. So you come back to the same 15, but if you're not using the design after 5 years, then there is really no need to renew it. And so you have the option to renew or not renew. And you can do that again, like I said, you can renew it twice. Another feature of the new law is that there is deferment of publication. And so if you submit your design application, the registrar examines it and says, okay, we are ready to accept this design. You can choose to defer the publication of the design because under the new system, once your design is examined, if it's accepted, we're going to publish the design in the Jamaica Intellectual Property Office journal. And then that will allow the public to object or oppose to the registration of the design. And so under the new law, you can defer publication for up to 12 months. So like I said before, there's going to be publication and it's going to come with it a 2-month opposition period. And basically anybody in the public can oppose the registration of a particular design. And also under the new regime, once a design is registered, anyone can bring a revocation action to essentially revoke the registration of a design that has been registered. So we don't have those features under the current regime, or they're not as fleshed out. We also have public inspection of the registrar under the new regime. Okay, so we also have, because there's public inspection of the register allowed, there's also rectification of the register. So anybody can apply to rectify an error in the register. And like we mentioned before, the new law has provisions that will allow us to participate in the Hague system for international designs. And then under the new law, there are also new offenses. So there is the offense of falsification of the register and for making false claims regarding a registered design. And so if you know that the design is not yours, but you still submit the application and you are essentially lying to the registrar and saying that, yes, I am the owner of this design, and that is proven to be a lie, then you could be subject to this penalty or this new offense. Okay, so like I mentioned before, the rights of the owner of the design rights, again, you have a monopoly for the use or exploitation of the design. And so to go into further detail as to what that means, you essentially control people reproducing the design in manufacturing, you control the imports, offering for sale, exposing for sale, or selling a product which reproduces the design. And you also control the stocking of any product which reproduces the design for sales purposes. So again, you have a monopoly and you control the market for the registered design. That is what design registration offers. Some of the exceptions under the new law to this power or to the monopoly of the owner is that you can't say that somebody is infringing your design rights if they're using your design for experimental purposes or if they're using it in the context of non-commercial private acts. Also for teaching purposes, so if they're using your design for teaching purposes and they're basically mentioning that the design is yours, they're citing you as a source, then that is also an exception to infringement. There are other exceptions under the law, but those are some of the three major ones that would probably be the most popular provisions. And so these exceptions are similar to the fair use provisions under copyright law. So I know a lot of people are creatives and are familiar with the copyright regime. So these provisions are similar to those exceptions. The new law also speaks to employer and employee rights. And so basically under the new law, if the design is commissioned by someone, then the owner of the design is the person who commissioned the design. If the design is created in the course of employment, then the design is owned, or the proprietor of the design is the employer, not the employee. If the employee creates the design on their own time, then the employee in that situation would be the owner of the design. However, if the employee utilizes work resources to create the design, then the employer would be the owner of the design. So the law basically goes into lots of different scenarios as to when an employer versus an employee would be the first owner of the registered design. But it also allows for the recognition of employees' rights to compensation. And so there's a clause in the law where even if the employer is the owner of the design, the law allows for employees to be compensated if they contributed to the creation of the design. So what are the costs under the new regime? So as you can see, the cost is broken down pretty much in two parts. So once you apply, and then after we examine, if we accept the design for registration, then you have to pay a publication fee and a registration fee. So the application fee, the initial application fee is $7,500, and that's for registration in one class. For each additional class, remember under Locarno, you have up to 32. It's an additional $2,200 per class. And then once the design is accepted, you pay $3,500 for publication and another $3,500 for registration. And so to register a design in one class from start to finish would cost $14,500. on the new system. Okay, so the new law, like we mentioned before, it will allow us to participate in the Hague Agreement. And so there are provisions in the new law that allows Jamaica to accede to the Hague Agreement. And so the Hague Agreement is administered by WIPO, and like I mentioned before, it enables a local designer to file and register designs in all Hague Agreement member countries worldwide. I believe there are 71 or 72 member countries. And so it's basically a shortcut. Instead of you having to retain an attorney in the European Union, for example, if you're gonna be exporting your designs to the EU, instead of having to get an EU attorney and paying those attorney fees and those filing fees, if you go through the Hague Agreement, then you're paying all of the fees upfront to WIPO, or you can do it through JIPO, and you don't have to pay all of these external fees. It's like you're already in the system and you're interacting with the respective national offices by way of WIPO. So once the Hague system or joining the Hague system goes into effect, you'll be able to file your international design application through JIPO, or you can do it through the eHague, the electronic Hague system, directly with WIPO. And so it's an online system, it's fairly user-friendly, and you can just submit your application directly, upload it to the system. You pay the fees directly to WIPO. Fees will be payable in Swiss francs, and depending on how many countries you want to register your design in, the fees will vary. And then for those applications, WIPO will publish the designs in the WIPO Designs Bulletin. So it's basically an international journal that will publish your designs. Again, you can defer publication for up to 12 months. And again, similar to the local law, the maximum duration for protection of the international registration would also be 15 years. So that's kind of the Hague Agreement in a nutshell. So like I said, it's mostly administrative. It's a shortcut to get your design registered in foreign jurisdictions. So we're going to actually be having a webinar on Thursday at 10, where we're going to be going into more detail about the Hague Agreement and what that means for local designers. We're going to have a speaker from WIPO who will be able to speak in more detail to the Hague and how it operates. So if you're interested, I will send the link. And if you go to our website, you should be able to register for that webinar as well. So that's pretty much designs in a nutshell. But as you know, it's Global Entrepreneurship Week. It would be remiss to not mention the trademark system, because usually entrepreneurs aren't just registering their designs, but they're going to be selling these designs under a particular brand. So whatever your company name is, you're going to be using that as the face of your enterprise under which you're selling your design. And so it's important to protect the brand or the logo of the company. And so that's where trademark protection comes in. And so a trademark is any sign that is capable of being graphically represented and capable of distinguishing the goods or services of one enterprise from the goods or services of another. And so again, trademarks you interact with daily. If you go to the supermarket, you know the difference between Grace, Eve, Lasco. All of those things are examples of trademarks. And you know that consumers will have specific brand loyalty to a particular brand, and they'll associate a particular brand with a certain level of quality or service. And so trademarks can be very powerful to market your designs. And so in order to protect your trademark locally, it's a similar process where you submit an application. You tell us what the trademark, what the sign or logo is supposed to be. You tell us what class you're going to be protecting it in. So what are the goods or services that you're going to be using this trademark on? So it's similar to the design application. Then we will examine your application after we do a search of the registry to see if your trademark is already registered or if there is something similar on the register that would bar registration of the trademark. Under the trademark law, there are similar bars. So if you're going to be using the flag or the national emblems like we talked about in the design context, you will also need to get permission from the Office of the Prime Minister if you're going to be using any of those things in your trademarks. And also the country name qualification, where we will look to see if your trademark is misleading. If you're using Jamaica in your logo, then there has to be, it can be misleading. There has to be some connection of the goods and services with Jamaica. The overall process for trademark registration can take anywhere from 10 months to a year for completion. So once we examine your application, if we accept it, similar to the new design regime, we will publish the trademark and then it will be open to opposition. It's a similar 2-month opposition period where anybody can oppose. And then after the opposition period closes, we'll proceed to register the trademark. Again, similar to the design system. The term of protection for a trademark is 10 years. But unlike a design where after 15 years, you cannot renew it, you can renew a trademark indefinitely. And so it's important that, as you continue to innovate as an entrepreneur, after 15 years, you might not be using some old design that you came up with. However, the strength of your brand is still viable. It can be viable indefinitely. And so as long as you keep innovating, coming up with new products, then all of them can be under the umbrella of your trademark. And so it's important to take steps to protect your trademarks. So these are some examples of trademarks that are registered locally. You might be familiar with them. Walker's Wood, Scotchies, Red Stripe are all well-known trademarks. And so again, this just goes over the process that I mentioned before. So you're going to submit the form, so called a TM1. You're going to have to give us representations of the mark. So you have to show us what the trademark is going to be. And then you have to tell us what goods or services you're going to use the trademark on. So in the design framework, we use the Locarno classification under the trademark system. It's another international classification system. It's called the Nice classification. That one has up to 45 classes of goods and services. And so you have to classify your goods and services using Nice, give us your particulars, and then we'll examine to see if it qualifies for protection. So the fees for registering a trademark. It's 7,800 to register to apply in one class. For each additional class is 2,200. Once the mark is accepted, then it is $10,000. So it's a publication fee of 2,200 and a registration fee of 7,800. So to register a trademark in one class currently comes to a total of $17,800. But like I said before, the trademark you can renew indefinitely, and it's central to protecting your brand identity. So that is what I have. So if you guys have any questions, let me know.
Okay, thanks, Adrienne. That was very much a very thorough and detailed presentation about design protection. I had some questions placed in the chat earlier, but I think you addressed them. But I'm going to go back to some of the earlier ones just in case
Okay.
they were missed. So we know that the patent, you just mentioned it, is when you register it is for 10 years. So that was one of the first questions. And it's renewable at the end of that time. And
That's the
then we have,
trademark.
that's a
You said,
trademark.
right. Okay. Yes.
Right. Patent is 15.
So patent is 20. So
All
remember,
right.
patents deal with innovation. So that's a whole different
And
IP,
that's
right?
tomorrow.
So that's tomorrow.
Right.
So remember that designs, you can't use designs to protect something that's functional. So if it's functional and it's like serving some kind of technical function or purpose, you would use a patent to protect it. So that would be the IP, right? That protects functional
Right. So
IP.
that's the distinction to note, that the patent is for the functional aspect of a product and the
Right.
design is for the aesthetics of the
Exactly.
product. Great. Clear. And tomorrow we hear all about patent
Right.
protection.
Yes.
There's a question about what happens if someone has used your industrial design. I guess they're asking what steps it is that you can take. What do you do?
So if someone uses your design without your permission, then that could be an infringement of your design rights. And so then you'd need to speak to an attorney that specializes in intellectual property to find out if you have a valid claim for infringement of your design rights.
Can they contact JIPO for that kind of support? Could they call you?
No, so because JIPO is the registry, we focus primarily on the registration of the design right. But then once you go towards enforcement of the rights, then you're in the remit of the court. And so that's why you need a lawyer to advise you on whether or not you can bring a claim in court for infringement.
Okay. And so that's very important to note, because sometimes that's a question that comes up
Yeah.
when we bring up the whole issue of needing to register your intellectual property because of the value that's in it. But people aren't necessarily clear on, okay, how it is that I actually defend this. How do I
Mhm.
then pursue any kind of treat process to actually seize the infringement, or to even get some kind of compensation for breaches that may be so egregious that they will warrant that kind of move. So it's one thing to get registered, but you're saying that the onus is also on the entrepreneur and the owner of that intellectual property to be vigilant and have some process as to how they monitor the use of it, right?
Yes, exactly. So again, I I analogy that I like to use is that intellectual property rights, think about it in similarly to a real property right. And so if you have a piece of land that's real property, right? And so you would go to the register of titles and we can give you your title. In the same way, JIPO will give you your certificate of registration. But then if somebody is supposed to squat on your land, as the landowner, you have to start the action to break their squatting on your land. In a similar way, if somebody is infringing your intellectual property rights, then you have to take the steps to protect your intellectual property.
Um,
So one thing that people can do is that they can go to the Jamaica Bar, their website, they have an IP subcommittee where you can find a list of attorneys that specialize in intellectual property, and those attorneys might be able to assist you to determine whether or not you have a claim for infringement.
Thanks. That I was going to ask that. So thank you for actually providing that answer. I was also going to ask if you have any tips on how it is that the entrepreneur, the owner of an intellectual property asset, can go about monitoring the any infringement, or how it is that asset is being utilized, if it is. Any tips? I don't know, because it seems like the world is such a big place, and it might be a little daunting to say, yes, I own this, but then how do I track it? How do I know?
So the world is a big place, but usually what happens is designers or entrepreneurs will be the ones who are most familiar with what's happening in their relevant markets. Um, Also, their attorneys and also search firms that offer that service where they'll monitor, be it journals or the internet, they'll look to see that there aren't people trying to infringe on your rights. So there are search firms that offer that service where they will monitor if your trademark or your design is being used. But most times, if you're in the market, if you're in the space, you have a pretty good pulse on whether or not there is something that comes out that is eerily similar to something that you have. And so that's why it's important to register your rights, because what that does is it's proof that you came up with this design, you know, at X time. And often in infringement actions, it comes down to who came up with it first. And so you want to pay attention to your designs and when you create them. And if you think it's something that is going to be central to your business, you want to take the extra step to register it so that you have proof of, you know, when you created this design, when it was registered, because again, that could be important in any infringement action.
And Adrian,
Mhm.
I heard you just now when you said it's usually a case in a dispute. It's usually a case of who came up with it first. Is it so, or is it who registers it first? Because it's about the proof of the registration is the proof, right? If I'm understanding clearly.
So if you registered it, then it's prima facie. So what that means is that the burden of proof then shifts to the other person. If you show your certificate in court, then there is a presumption that yes, Adrienne Thompson, at least as of the registration date, had this design. Okay. So then the onus will shift to the other person to come up with evidence that, I don't know, that either your registration, for example, would be in bad faith. So that would be where revocation comes in. So for example, if it's you and somebody else and you worked on it together, but then one of the partners decides to go ahead and register it without involving their partner, then that could be an action where one person says, yes, I registered it, but then the other person could prove that that registration was essentially in bad faith. And in fact, this this other person, even though they don't have registered rights, can show based on what evidence they're going to submit that they in fact are the ones that are the proper owners for the design. So yeah, that's why you need a lawyer to kind of guide you through the process because it can get complicated.
Okay. Yes, these matters are very important in terms of the technical side of it, and it's not something that it's easily navigatable by the entrepreneur. It's just a lay person.
Right. So
Um,
that's why the lawyer is important, just to guide you through it.
Yeah, and I mean, you're just making the point even further and stronger that when we do make these moves about creating valuable intellectual properties, that we also have to go about educating ourselves about how it is that we then manage these things, because it's not just a simple thing as having the certificate and having that part done.
Right.
Another question that I'd like you to just reiterate, because you did address it before,
Mm-hmm.
is um, for something to be protected internationally, what body does local artisans have to engage with? Now we know that is going to be the Jamaica Intellectual Property Office as the registry here, but they want to know, is it that when they come to you, you support them with the international registration?
So once we join the Hague system, which we're hoping will be by next year, to begin by April of next year, um, you'll have the option of two channels. So you can come to JIPO and we'll help you to submit your international application, or you can apply directly to WIPO, which is the World Intellectual Property Office, if you want to apply for an international registration. I'm not sure.
If they do the direct application to WIPO, is it that they
Mhm.
have to do this on their own, or do you support them as well?
They would be doing it on their own, but again, JIPO is always here to assist. And so if they have any questions, I mean, they can always contact us via email or call, and we should be able to assist them.
Okay, great. Final question that I'm seeing here. I'm not seeing any new ones coming up since we've been talking, so I take it that this is the final question. And it relates to claiming the right of a design. And it says, if an employee creates a design on an employer's laptop, but the
Mhm.
design was done outside of work hours and for personal reasons, can the employer make claim to the design?
Yes, the employer could make claim because you're utilizing the resource of the employer in its creation. And so using the employer's laptop means that the employer could say, well, I have some kind of right to this design because without my laptop, you couldn't have created it. And
Wow.
so if you are going to be creating a design and you don't want it to be, you know, something that somebody else could make a claim to, you want to use your own devices, you want to make sure you're doing it on your own time, not on your employer's time. And then you also want to make sure that you pay attention to your employment contract. And, for example, if you're working with somebody, you're a designer, but, you know, some designs in your employment contract, you can say, okay, if it's designs relating to X, Y, and Z, then in the contract you can put out, yes, the employer will own those, but the both of you can agree that if, you know, if there's some other parameter or some other condition, so if the designs relate to, I don't know, your side business that you've disclosed to the employer and you're both aware that this other thing is happening, then you can exclude those in the contract so that the employer can't come and claim that those designs also belong to them. So you just need to, again, this is where a lawyer is important, pay attention to what you're agreeing to and what you're signing away, because it could have ramifications down the road.
Well, that's a very interesting point raised, as I see it's prompted a lead question.
Okay.
That's if you create a design on your personal laptop for
Uh-huh.
work, is it yours or the company's?
Okay, so if you create it on your personal laptop, but it's for work, then chances are it's for work. So if they have commissioned that you create this work, this thing, this design, and you do it, it's a part of your employment, your terms of employment. So likely it would be their property, even if you do it on your own laptop.
And that is why
You shouldn't be
contracts
doing that. You should just be using work resources.
using, yeah, it's usually the contra where you're using work resources or there's work resources being used personally. But
Right.
it's also possible, and especially now in this advent, this space that we're in of working from home and all of that, where resources are a real issue. Some
Exactly.
people
So
are
now is a
using their
good
personal,
time
yeah.
to pay attention and start the conversation, maybe revisit so that
Yes.
everybody's clear as to what belongs to who, and not just have a conversation but get it written so that
Hmm.
if something happens down the road, then you have, no, we agreed in writing on X day that this belongs to me, this belongs to you. So yeah.
Yeah, very, very topical point at this stage.
Yeah.
Oh, okay. So I'm not seeing any additional questions popping up from that.
Okay.
And in that event, I will take the opportunity now as we wrap up this virtual Biz Zone session today and the first in our Global Entrepreneurship Week of events. I want to thank you so much, Adrienne Thompson, for giving us a very, very fulsome conversation and discourse on the matter of this updated Design Act. I'm seeing from the comments that were there that it was useful to those who are in the virtual session, and I'm sure it's going to have added value for those who watch it even beyond it today. So thank you so much for your time and the information that you passed on, and we're really glad that JIPO has partnered with us for this GEW to make it a very impactful one for creatives and other entrepreneurs. So
Okay, thank you for the opportunity, and I will share the presentation so that if people want to see the slides, they'll have access to them as well. So I'll share that with you and
And do you
distribute it.
just want to quickly run through? I know it's on the screen, but do you just want to quickly run through how people can get in touch with JIFO, especially now?
Sure.
Are you working in office now, or are you still
I am
distancing at home?
currently in office. Yeah, JIPO is still open to the public. You can come in. We're open until 3 in the days from 9 to 3. We're at 18 Trafalgar Road. But you know, it's COVID time, so you can call at 946-1300. You can call our office or you can send us an email if you have any inquiries at info@jipo.gov.jm. We're also currently offering a service where you can submit your applications via email, and we are working on improving our online system so that you can file applications online, but that is down the road. We're
Okay.
working on it. And again, if you have any questions, my email is my name, so it's adrienne.thompson@jipo.gov.jm. You can also email me directly, and yeah, we're here to assist.
Wonderful. Thanks again. And this was with us this morning, Adrienne Thompson, Manager of Trademarks, Designs, and Geographical Indications at the Jamaica Intellectual Property Office. Thanking you again and have a good day and enjoy the rest of GEW. All right. And before we close off, I just want to run through again for you guys who are here on the Zoom with us what it is that we have in store for the rest of the day and the rest of the week. So, following this morning's virtual Bizstone session, we are going to be having another session at 1 p.m. And this is going to be looking at social entrepreneurship, and it's called the Business Dialogue Forum. It's a panel discussion, and we're looking at unlocking youth innovation through social entrepreneurship. That is probably, and we're having a lot of issues, a lot of problems. If we never had them before, boy, COVID reality and COVID economy has been bringing out that there are a lot of problems that our societies are facing, and that social entrepreneurship, using the ingenuity, the creativity, and the innovativeness of entrepreneurial practices and pursuits, can solve these problems, and the solutions are coming from the youth. They are on the ball, they know what's going on, they are keen on the technology and the ways to bring newness and clarity to some of the issues that are here. And so we're going to delve into that conversation this afternoon. I encourage you to join us at that time. And tomorrow we have another virtual Biz Zone session in the morning, and that is going to be looking at another dialogue, another panel conversation that looks at the theme in depth, innovating, ideating, innovating, and activating. So from concept to market, we're going to have a conversation about how it is that we here at JBDC provide support to this process of ideating, innovating, and activating, and how we do that across teams here. And in the afternoon, I think we're going to have a practical session with our resident Nigerian cultural diplomat who's been with us here at JBDC for some time now, Alao Lukman. And he will be looking at simple techniques in bead making. So this should be fun and interesting. So I encourage you to join us again tomorrow at 1 p.m. for this session. And on Wednesday, I mentioned that they'll be designing with Sealdon and UCC, and we have the JBDC in concert as well in the afternoon. And this is always featuring our creatives. We're looking at the creative sector and how it is that the mapping that has been undertaken is going to be supporting this sector, what the results have been, and what some of the recommendations have been emerging from this assessment that was done. And on Thursday, we have Brand Jamaica Design Lab. This is at 1 p.m., driving innovations in gift and craft. And this is another conversation delving into the creative sector. On Friday, we have the entrepreneur's journey, which is where we delve into the entrepreneurial journey of one of, we call them the rising icons and the established icons in the Jamaican entrepreneurial space. But this Friday, we're going to be doing it on GEW style with the looking at the boss man. We every year JBDC has been doing this for a few years now, where we look at the entrepreneurial spirit and mindset, and those entrepreneurs who are embodying innovation and showing this tangibly with movements in their sales, in their employment numbers, and how they're making moves in new markets. And we have four nominees on Friday afternoon that we're going to be looking at 12 noon. And then right after that, we move into the awards ceremony for who will be awarded the JBDC Bossman and Bosswoman for 2020. All right, so that's it. A week packed full of activities for you, and we hope that you stay engaged with us throughout the week because it will be very informative. And we want to hear from you as well. So participate. You know, the Zoom chat, that's because we're not face to face, doesn't mean it cannot be interactive. So do participate via the Zoom and email and call us and all these things. We look forward to hearing from you. Thank you again for sharing this morning with us, and have a good day.